Thanks very much. We want to just respect everyone's schedule. It's really great to see everyone in person. I know this arbitration week was a little bit uncertain. We're hoping to have a lot of the speakers in person, but of course the quarantine has prevented that. We do have a distinguished panel today. I'll give it a brief introduction in a moment. But quickly, just to cover the topic. So today we're really talking about not arbitration, but what to do in the time leading up to an award. In a situation where is increasingly common, where a debtor doesn't pay, the settlement negotiations may stall out. They may ignore the proceedings. There may be tactical winding ups to benefit from a moratorium or an automatic stay. And in some cases where we have personal guarantors, there may be efforts to abandon the jurisdiction. So there's going to be a focus on creative approaches, and it's going to be about greater China, and some of the things that the distinguished panel has done in the past and tactics to try to drive settlement, as opposed to going through the lengthy and arduous process of what we usually call a freeze and seize approach. So the New York Convention is of course familiar, but there's massive variations jurisdiction by jurisdiction in implementation. And of course, once you do have an award confirmed, the post-judgment toolkits are very different in different places. The devil is very much in the details. And today we'll really try to cover Hong Kong as the offshore financial center for mainland China, the PRC, some of the offshore jurisdictions, BVI and Cayman primarily, and then Korea. So let me begin by introducing the distinguished panel, briefly including myself. So I'm a partner with Kobre and Kim's Hong Kong office. For those of you who are not familiar with us, we're a disputes only firm, so there's no transactional practice. And maybe 60% of the firm focuses specifically on representing creditors, sometimes judgment creditors, sometimes arbitration award creditors, and sometimes pre-judgment creditors in bondholders, private credit, and things like that. Oftentimes on the order of 8 to 10 figures USD, typically in activist scenarios, but sometimes in pre-dispute work to kind of assess what scenarios may look like. Just a quick overview. We're outside of UCOS, the two largest arbitration awards in the world that are being enforced right now against the Republic of Nigeria and the Republic of Venezuela. Those are two active matters that we're working on. One is for 9 billion, the other is for 8.7 billion. So I'll just go around the panel briefly. I'll start with Sung-Min Lee. Ms. Lee is a partner with Peter and Kim in Singapore. She's a dual qualified Korean lawyer and a solicitor in England and Wales. She's represented major Korean and international clients in arbitrations under a wide range of institutional rules and acted extensively in multi-billion-dollar cross-border enforcement matters. She's part of the team currently representing Mira Asset in the $6 billion dispute concerning the sale and purchase of 15 luxury hotels. And then she's also represented Lone Star Funds in a 4.6 billion ICSID claim against South Korea, the Republic of Korea. So Ms. Lee was ranked between 2016 and 2021 by Chambers as also recognized as a future leader in arbitration by Who's Who Legal between 2018 and 2021. Next we have Ms. Heidi Tung. Ms. Tung is a partner with Kingwood Mallison's Shenzhen office, she's waving, specializing in cross-border disputes, PRC and overseas litigation and arbitration, financial disputes, acquisition and disposal of non-performing assets, non-performing loans, and more. She successfully represented and participated in a large number of international litigation arbitration cases at all levels of China's courts and arbitration institutions, including CTAC, SCIA, HKIC, often involving high-profile domestic and foreign companies. She's represented foreign funds and other foreign creditors in connection with the liquidation and restructuring procedures onshore and offshore, and represented creditors in participation in the negotiation with governments and with liquidators. She's also handled recognition and enforcement of foreign judgments and arbitral awards in the PRC court system throughout the country. Cases that she's dealt with include cross-border loan and guarantee disputes, international trade, cross-border equity investments, financial derivatives investment disputes, and corporate equity related disputes. And then lastly, Jason Kong, currently in Shanghai, is my litigation partner at Kobre and Kim. Jason focuses on China offshore cross-border disputes related to international claim monetization, typically of judgments, awards, defaulted bond, and private credit, oftentimes involving personal guarantees and certain allegations of fraud, which we'll get into in a moment. Mr. Kong has acted in a wide range of China-related monetization matters involving SOEs, multinational corporations, ultra-high net worth individuals, including recently elements onshore in China, here offshore in Hong Kong, the US, UK, but critically, I think with the important focus of BVI and Cayman, and often Delaware, and then also involving arbitration seated in HKIC, and then applying the ICC rules. So with that, why don't we just get started? Heidi, I'd like to start with you. I think the centerpiece for us today is the PRC. The PRC is a relatively pro-enforcement jurisdiction when it comes to foreign arbitration awards. Confirmation is typically decided very quickly. There's a review by the Supreme People's Court if confirmation is denied. But nowadays, given economic distress in the pattern of leverage, maybe over leverage by PRC companies, award creditors increasingly, I think, face situations where there's either significant insolvency risk by the counterparty, and then in that situation, there's a risk of dilution amongst the creditor body. There may be strategic winding ups by the counterparty to benefit from the stay or the moratorium, as I mentioned earlier. And it may be as a creditor, there may be some benefit to tactically winding up certain entities in the group. This is complicated by the fact that assets are often located onshore, but the incorporation is offshore. There may be a listing in Hong Kong. So what I wanted to ask you was, as a PRC practitioner, what are your typical recommendations for your clients to consider in terms of tactics in this type of environment?
Thank you, John. Before I go through my slides, I think your questions has been actually a very big problem for all the creditor, especially offshore creditor. When you have to go into China, I try to enforce your arbitral award or judgment, especially when during the turbulence of the economy, it's actually very common to see a cross-border liquidation. When you have the creditor apply for a Hong Kong liquidation order, then you try to bring this liquidation order into mainland China and try to enforce such liquidation order. But then, as you all know, that I will go through my slides and talk about, usually you can only enforce arbitral award or judgment, but there has never been a recognition of the bankruptcy proceedings order or judgment. So what usually the creditor will do is use the control of the directors or the board, try to appoint new legal representative, or try to gain the control of the company. Then probably try to remake the job, reapply for business certificate, and so on. But that's always a very ugly battle when the assets are in China. But now we have something, a new mechanism actually can help you to monetize your arbitral award if the company actually go through an insolvency proceedings in Hong Kong. May I go through my slides now to probably introduce this minutes signed by the Supreme Court and Hong Kong government?
Yeah, sure. That sounds great.
Okay. Please allow me to share the screen. Because this is a very new opinion. So can you see my slides?
Yes.
That's wonderful. Okay. So as you can see that there are minutes signed actually between the Chinese Supreme Court and the Hong Kong government. So this is actually a structure. It set out the structure of the legislation. And then you have the opinion, which actually have more details, just like, provide a guideline. I will discuss some of the key points of the opinion, so you can see that what kind of new mechanism a trustee or administrator can use in mainland China. As you all know, and I also show on my slides, there are some reciprocal arrangements of recognition and enforcement of judgment, and also the arbitral award between mainland and Hong Kong. An order in bankruptcy proceeding, however, as I just mentioned, is excluded from all these measures. So this new minutes and the opinion are very important as a mechanism to enforce your assets in China. A little bit background, actually, why we need this reciprocal arrangement regarding the recognition and assistance of bankruptcy proceeding, because based on the latest data, there are a considerable amount of trading between mainland China and Hong Kong. And also due to the turbulence of the economy, we actually see more and more cross-border bankruptcy cases. I will show you some leading cases that's happened in recent year in a little bit. So which are the pilot cities? There are actually 3 pilot cities under the opinion, which is Shanghai, Xiamen in Fujian province, and Shenzhen in Guangdong province. Because these 3 cities historically have more Hong Kong investors, probably opening factories or have equity investments in these 3 cities. So what type of insolvency proceedings that actually can be recognized and assisted by the mainland courts? So the opinion set out the applicable type of cases. What we so-called, according to Hong Kong company ordinance, something called collective debt liquidation procedure. These are the cases that will be recognized and assisted in China. So bankruptcy proceedings, unfortunately, for individuals is excluded from this opinion. And also what kind of, debtors or what kind of cases that can be recognized. That is what we call a center of main interest principle applies here, which means the opinion applies to Hong Kong insolvency proceedings, where Hong Kong has been center of main interest of the debtor continuously for at least 6 months. It generally means place of incorporation of debtors in Hong Kong. So BVI or Cayman corporations proceedings may not be recognized directly by the mainland courts. Of course, the mainland courts will think about other criteria, but Hong Kong company incorporated in Hong Kong is more likely to be recognized by the mainland court. So when you have a case, so which city do you go to or which court do you go to? How to decide the jurisdiction of a court in these 3 pilot cities? So if the debtor's principal assets, or we call like core assets, are in mainland, to be more accurate, so if the core assets or place of business or the representative office are in Xiamen, Shanghai, or Shenzhen, then the intermediate court, not the basic court, but the intermediate court in the city actually have the jurisdiction over the bankruptcy case. What about 2 courts all have jurisdiction over 1 case? Then the court who actually accept the case first will have the jurisdiction over the bankruptcy proceedings. What kind of documents do you need to submit to the court? The opinion actually provide a very detailed list of all the material a Hong Kong administrator shall submit to the mainland court. You can see this list in great details, but we actually still trying to figure out some of the contents of certain documents because this opinion actually is very new. Regarding the contents of the applications, these are the informations that you need to actually contain in your application to the mainland court. You can see that they requires the Hong Kong administrator's information as well as the debtor's information. Unfortunately, it's, according to the opinion, you still need to go through the, the notarization and legalization proceedings in Hong Kong, because the order or the identification documents cannot be just used in China. You still need to go through that proceedings in order to be accepted by the mainland court. So if an application for recognition and assistance is accepted by the mainland court, it's then become very similar to an insolvency proceeding in the mainland. The administrator actually have a lot of procedural right. For example, you can maintain the status quo. All the relevant proceedings in mainland China will be suspended. And after the recognition, the administrator will have a better control over the assets. So no individual payment, and you can actually lift it, all the asset preservation actually attached or preserved by other creditors. So it's actually give the administrator a lot of control over the mainland China assets. What about the duty of a Hong Kong administrator? You can see there are a lot of things the administrator can actually do in mainland China. There's something very interesting because all the creditors actually ask me questions regarding how to find asset clue in China. Because a lot of information, for example, the real property information or bank account information are confidential. Sometimes the creditors need to hire a private investigation company to find asset clue. But after the bankruptcy proceedings is recognized by the Chinese court, then as an approach to assistance of the administrator, you have the right to investigate the financial position of the debtor. So that is actually a very powerful tool for the creditor or administrator to find out the financial situation of a debtor in mainland China. And what else you can do? You can also try to hold the meetings and also try to dispose of the assets, try to actually accept the creditor's claim. Then you can actually able to identify, are there some fake debt? Are there some collusions between the affiliate company of the debtors? These are all the things that you can do in mainland China. Well, there are some, situation or reasons the Chinese court may refuse to recognize such order. It's usually including a fraud, or as Article 2 of the enterprise bankruptcy law is that the company is actually not insolvent. So if the debtor can prove that they have enough assets, so then it's not become insolvent, the Chinese court might then refuse the recognition of this order. What about the bankruptcy property? After we get a hold on all the bankruptcy property, the preferential claim in mainland China, that's usually include the payment for the labor, for the workers, but also the taxes for the government. Those are the preferential claims. And then the remainders will be distributed among all the creditors. After we discuss a little bit regarding this opinion, what kind of opportunities for professionals? I think this is a very exciting and very important piece of legislation this year, It's because we can see a lot of cooperation in the future between the accounting firms, the law firms across the border. And also within the Greater Bay Area, we noticed that actually Hong Kong legal professionals can actually take an exam and practice in the Greater Bay Area as legal professionals. So we'll definitely see more and more cooperation between Hong Kong and China and within a Greater Bay Area. Oh, these are the leading cases I just mentioned. It's actually, I would like to discuss one case is about a Shenzhen company called Everreach Supply Chain Company. I personally actually involved in this case, not on behalf of arbitrator, but as a lawyer for one of the creditor. The thing is, this company is actually a Shenzhen company, but it is actually a trading company. So all the account receivable actually has been received in a bank account in Hong Kong. That's the reason why the administrator needs to go to Hong Kong and make an application to the Hong Kong court for recognizing a Chinese bankruptcy administrator's legal position in order to actually stop all the litigation in Hong Kong and also to take control of all the bank accounts in Hong Kong. So this concludes my presentation in introduction to this opinion. And back to you, John.
Thank you very much, Heidi. I think it's a topic that's going to be of increasing significance. Arbitration award creditors, as everyone I'm sure knows, are junior creditors. They're in the general unsecured body. And so this cross-border and this crossover between enforcement under the New York Convention and insolvency is going to be increasingly relevant, I think, especially with the environment of a binge on leverage, challenges with refinancing. I think next year in particular, we'll see some interesting test cases on the statute. Why don't we move on now to Seung-min? I think you have a unique perspective of having represented some counterparties in major disputes in Korea with adverse to online or Chinese onshore counterparties. So we've seen an increasing level of cross-border investment in recent years between the two jurisdictions. With these collaborations and joint ventures, there's more and more disputes. And then in a subset of those, there's significant enforcement obstacles. So what's your experience been with enforcement of arbitration awards in China on behalf of Korean clients? And I think particularly it'd be interesting to hear about how that contrasts with the experience that your clients have had with enforcement of awards in Korea, which is another code-based jurisdiction.
Thank you so much, John, for having me here, first of all, and the kind introduction. So I'm Seung-min Lee, a partner at Peter & Kim. And yes, so before I go into talking about the obstacles I faced with enforcing an arbitral award in China, maybe it would be helpful for me to share some of the things that what China has been doing to facilitate the enforcement of an arbitral award, and also try to what they have been for, especially for those people who are not familiar with this area. So as you will already know, China is a signatory to the New York Convention. So unless they tick the box specifically mentioned in the New York Convention, the Chinese court cannot actually refuse an arbitral award to be enforced. So to facilitate and support that New York Convention, and also for the Supreme Court to actually control the lower court as well, as Heidi has kindly mentioned, they implemented this internal reporting system where all of the lower courts, whenever at the lower court level as well, when they are trying to refuse an arbitral award to be enforced, then they would have to internally report it to the Supreme Court and get an approval, and then it would come down, and at the lower level, they would be able to refuse an arbitral award. So that's basically the system, which I think it's be fascinating. So it sounds like a fantastic system already in place. So would that mean that all of my experience enforcing an arbitral award in China was like only rainbow and flowers over there and only happy endings? Well, unfortunately, there were some obstacles and some bumpy areas. So I think I will use this opportunity to share some of those elements, some of the experience there. So starting with the reporting system, I think it's a very creative, great system. But at the same time, it can be a double-edged sword, because what I've experienced, it was an HKIC case seated in Hong Kong against a Chinese big company in the rural area. And we were representing the Korean client. And we were trying to enforce this arbitral award. And at the lower court level, they would, because of this internal reporting system, all of the judges at the district court level that would gather together and discuss and share their views on the merits of whether this arbitral award should be enforced or not. And this arbitral award is the members of the tribunal was the so-called stellar arbitrators, the big names, all of them. And it was under the HKIC rule. So it was, as an arbitration practitioner, in my view, although I was representing my client, the Korean client, it did not really have a lot of any flaws. It wouldn't tick any of the boxes under the New York Convention. But even still, there were a lot of talks, and they were raised so many questions like translation or these minor issues, but it was all already discussed. So that was a very interesting part. But so from the lower court level, all the judges would gather together and discuss, and then internal report to the intermediate court. And then all the courts from the intermediate court would also gather together and discuss. And then they would eventually report to the Supreme Court. Of course, the Supreme Court said that, well, there is no way you're not gonna enforce this, so please enforce it. So they did not get the approval. So it came down to the lower court level. So I got the judgment happily. But is this also the end of the story? Because I would say not really, because around the time when I filed my notice of arbitration to the Hong Kong HKIC, I was pregnant. And then around the time I got the judgment from the Chinese court, my daughter was singing Ishan Ishan Yang Xing Xing Manshen Doshi Yu Xing Xing. So it means it took a long time to actually get the judgment. So the intermediate court and reporting system can be a double-edged sword, because first of all, it's opening up the gate for all the court judges to express their own views, and although it's internal, but it's very, I think that's a very unique system, because in most of the jurisdictions, when a judge is hearing a case, another judge, even the next door judge, would not be allowed to actually express their opinion on that particular case. But in this case, it was open to a lot of views, which at the end of the day, it would be also opening up the risk to be influenced by the local influence as well. So that was one of the elements that I observed. And second is, after I got the court judgment, we went back to the area, and unless the other party voluntarily agrees to comply with the monetary order, actually we have to go through coercive measures. And the coercive measures should be done by the aid of the Chinese court, the local court again. So every approval to assess the value of the factory, the property, everything, it involved and needed approval from the lower court level. So again, we've seen a lot of proceedings being drained and delayed because of those local influence. So as a foreigner over the past 15 years, representing a lot of foreign parties, including Korean parties against Chinese parties, I would have to say that we hear from the Chinese government clear and loud that the clear message that if you're going to, as a foreigner, if you're going to invest something in China, you are going to be guaranteed that the dispute resolution mechanism and also the enforcement, we will have that in place. So please come in and invest. So we hear that the message is clear, but still there are small sort of variables that could be very bumpy to the foreign parties in actually implementing and enforcing an arbitral award. That's my experience.
Seung-min, I think that's really interesting, and I think the practical aspects from your perspective of a non-Chinese investor in China and then dealing with dispute resolution and what kind of the post-judgment experience is, as opposed to just the confirmation experience, is really enlightening. I did want to ask you, in situations where the enforcement has not gone smoothly, and we talked with Heidi earlier about solvency issues, maybe there's just a unwillingness to pay even though there are no solvency issues. What sort of creative approaches have you taken to look to achieve monetization when the freezing, valuation, and then execution route have been overly time consuming, perhaps resource consumptive, things like that?
Thank you so much. It's a very, 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 very good question, but not a simple question to answer, actually, because it also involves a lot of sensitivity. But I will share, and there's a disclaimer. I'm not here to offend anyone. I love everyone. I think every case is different. So as a disclaimer over there, and I would like to share some of the experience or some of the impressions that I've formed with my colleagues over the past years. So when directly monetizing an arbitral award is not easy, there could be like roughly 3 scenarios when your client is faced with. First of all, it's like nonetheless, you have to try to find ways to settle with the arbitral award. Settlement, we cannot emphasize it less. It's overemphasize it. It's a very important tool that you would always have to consider and advise your client even after the arbitral award has been rendered. Second is like a scenario where the Chinese party has been bankrupt, and thankfully it's a complicated area. Heidi covered it very well, so I don't feel like I should cover it right here. And then the last bit is actually trying to think out of the box and trying to utilize this arbitral award and try to indirectly gain some benefit for your client. Although you cannot, it may be actually difficult to directly monetize the arbitral award in China. So I will just cover the first bit and the third bit. And the first bit, so you will always, whenever we are dealing with a client, from the very outset, when you're starting a dispute, even after the arbitral award has been rendered, we would always advise our client to engage in negotiation with the Chinese parties, either because they can go back to their daily lives, or either to promise a different future business. And there are like 2 or 3 tips maybe that I can share, which I would have to say it's impression the foreigners have formed against the Chinese parties. And again, China is a very big, great country, so it's almost impossible actually to define or categorize them in just 1 or 2 words. So with that caveat, I would like to share some of the, maybe it can be biased, but some of the concepts that the foreign parties, including Korean parties, may have when they're engaging in negotiations. So one would be like, you have to engage in the settlement negotiation, but be careful because the Chinese parties can sometimes wear and tear the foreign side down with endless issues. And that's something that as a tactic they can do. They can either come up with many tactics at the same time, or after one issue has been resolved, they can move on to the other issues. So that's something that sometimes the Korean parties can face with when they're engaged in settlement talks. And second of all, they will always come up with these regulatory issues or say that China is different. So these are some of the tactics that we've seen. Lastly, sometimes after they have executed a settlement agreement, they are not shy to come back and revisit the terms, especially the key terms, even after the execution. So, and some people also say that the Chinese people consider the signing of a contract as a start of a new negotiation process rather than the termination. So that's something that we have been saying. So that's the impression or maybe the bias that the Korean parties may normally have when they're engaged in settlement talks. But at the same time, over the past 1-2 years, me and my colleagues have been also experiencing like Chinese opposing parties being also highly educated and also educated in the States with like good English skills and adopting international standards. And I'm talking about international standards not because they're inferior or superior to any other, but I'm just simply saying that it's a common language that we can easily understand when we're talking about business in an international setting. So that's something. So there are differing views, but I'm sharing these views as a foreigner when you're engaged in a negotiation, and hope that some of you find it to be helpful. The third element, the third scenario is actually it is very important as an arbitration practitioner to think out of the box. And I think Kobre Kim, as a dispute lawyer, you're very brilliant in doing that. Actually, I think that's your main job, thinking out of the box all the time, try to execute, monetize an award. So that's brilliant. So one of my personal experiences, I've been involved in many IP disputes, and how that IP disputes normally operate is like there is a main, very famous, successful IP holder, and then they will normally license to the licensees. And when a Chinese party is a licensee, then the Chinese party normally over the years, they're very clever, they're very intelligent, they know the market, they know what the people would love. So they will localize item, and they create a lot of derivatives using their subsidiaries, their son companies, their interested parties. So it becomes on the Chinese side, it becomes a massive scale of infringement to intertwine with some of the arbitral breach, contractual breach elements. So normally in this situation, in the license agreement under the arbitration, there would be an arbitral award, and then there would be also ancillary copyright infringement against these like subsidiaries and son companies and all the interested parties here involved in creating and distributing the derivatives. So in this situation, a party, some of the IP holders might be hesitant to actually commence an international arbitration, to resolve the dispute under the arbitration, because they might say that, well, at the end of the day, it would be very difficult to enforce the arbitral award against the Chinese party. But in this situation, there are other areas that we can definitely think. Over the past many years, I've always experienced whenever this happens and there's an arbitral award, although you cannot directly monetize arbitral award, the stock price goes up. The IP holder stock price goes up, and it's so massive, so that it's not an element that we can just add as a side note. It's something very important for always to remind the client that this is also a very big benefit that you're going to gain if you commence this arbitration and get a favorable award. Because in an arbitral award, normally it would state that whether the license agreement has been terminated, whether what is the actual scope of the IP license, and all these other declaratory reliefs also will be declared together with the monetary order. So using all the existence of the first bit, it would be very powerful. So the stock price would definitely go up. The second element is by using the first bit of the arbitral award, existence of a declaration by a tribunal declaring that the license agreement has been terminated. Using this fact and the arbitral award, you can actually license this IP to a third party in China. And if you enter into a license agreement in China and also give the licensee, the new licensee, a right to crack down any copyright infringement activities of the former licensee, then it becomes a very powerful tool for the new third party, the new licensee as well. Because online gaming business, online platform business, it's all about traffic. It's all about how you can get traffic. It's all about by way of killing the other platform to gain to shift that traffic to make it your own traffic. That's all of the gaming business is all about traffic. So if you have the right to actually crack down and shut down the other platform by copyright by using that the copyright infringement method, then it can be also a very, very business-wise powerful tool. So it can be all created and by using the existence of an arbitral award. You don't have to monetize it directly, but it can be utilized. So that's, I would say, sharing some of my thinking out of the box strategy.
Thank you. I think that's an extremely creative use of licensing with competitors to try to collaterally achieve, I think, what's quite difficult sometimes with a linear approach to execution, a very expensive approach. And I think the share price thing, what you mentioned, is also quite interesting, because I think it opens the door to financial hedging potentially on the outcomes of arbitration and enforcement risk, which is something that we've discussed in the past. I think the point that you really highlighted on is is extremely important, which is creativity is essential at all stages. And I wanted to pass it on to Jason, but I think the key transition point here is, for example, on the Mira asset matter that you're working on, we're dealing with awards and claims that are in the 9 to 10 figures USD, so billions of dollars. You actually can't find with a reluctant debtor a single or even several pools of assets that are going to sum up to several $1 billion. It would be inordinately expensive and oftentimes impossible. And so I think what you had mentioned with the licensing is really important. And, you know, Jason, I know that you focus a lot on representing Chinese companies in creditor disputes that really touch on Hong Kong and then offshore jurisdictions like BVI, Cayman, and Bermuda. And the ones that we've worked on together oftentimes involve fraud and complicated nominee structures. You know, some of them more sophisticated than others. I know one that we're working on presently, there was a transfer of assets to a BVI company that was owned by the chairman's 18-year-old daughter, which I'd say is on the less sophisticated range. But in these types of situations where you start to discover some elements of misconduct, what sorts of opportunities would you say you look for with this cross-border PRC offshore situation? And which jurisdictions do you tend to focus on? And what kind of, you know, alternative strategies can you look at, you know, maybe at decision makers outside of the standard freezing and seizing strategy that we've been talking about?
Yeah, thank you, John, for the questions. Yes, you know, part of my practice focuses on like monetizing awards, judgments, and other claims outside of mainland China against Chinese debtors from their overseas assets. And I believe like all of us in this meeting may have seen a lot of like evasion acts, like, you know, transfer assets in a fraudulent way or make untruthful disclosure in proceedings. And oftentimes that creates a lot of frustration to plaintiff claimants, award judgment creditors, and us as legal counsels representing them. That said, those fraudulent acts, on the other hand, also give us opportunities to exert great pressure to the respondents or debtors for quick settlement of discussion. And I often see the opportunities lays in twofold, and one is about the assets and one is about the individuals. So, you know, first about the assets, the act of moving assets around itself shows that, you know, from the respondents or the debtors' perspective, at least such assets available or of some importance to justify the moving around. And if we can put such asset back to the enforcement or create enough risk for that, usually it will render us some favorable settlement opportunities. So in one of our recent matters, at the beginning of the enforcement campaign, we knew that the debtor owns a Hong Kong trading company, but we did not know what assets the company actually owns. So it was not on our priority list for the enforcement targets. However, you know, during the proceedings, he transferred his shares in that Hong Kong company to a Chinese individual. And we found out that through a regular inspection of that company's register of members. And then we started saying that, you know, maybe this company worth something and it cares about this company at least. So we swiftly applied for a moratorium injunction against the debtor, the transferee of that shares, and the Hong Kong company itself on a tribal basis. And that eventually resulted in a very successful settlement. And, you know, at the end, we still didn't know, like, you know, what assets exactly that company held, but we know that there's something he cares about. And the second fold is about, you know, pressure on the individuals. When the debtors are trying to move assets around and think about, you know, to whose hands those assets should be transferred to, usually they don't have a lot of choices in terms of people who they can truly trust. So, and there's a strong temptation to transfer those valuable assets to someone they are very close to. As a result of that, in some cases, the nominee or the transferee of valuable assets turn out to be the debtor's key family members or important or very close business partners. And we often see, opportunities in those situations in extending our enforcement campaign or legal proceedings to involve those nominees and transferees. And those people's exposure to potential legal liabilities, contempt risk, or even just the fact that their names and their relationship with the debtors will be publicly reviewed in a judgment will usually create some useful leverage in our settlement negotiation with the debtors if the debtors care about those nominees individually. Drawing the matter you just mentioned about the debtor transferred a holding in an offshore holding company to the ultimate controller's daughter shortly before they sold part of the asset of that holding company at undervalue. We discovered that through a knowledge application that the holding company was transferred to the daughter. And then we applied for an injunction on tribal basis to include the daughter and also the holding companies. We also filed proceedings against the daughter for conspiracy. And by doing that, we successfully involved the daughter into like a lot of very complicated legal proceedings in different jurisdictions. And that, I believe, give enough pressure for the debtor to come out for some settlement proposals. And that's usually like how I see where the opportunities are in terms of those fraudulent acts.
Thanks, Jason. I do want to leave a little bit of time for Q&A, but I think it's really nice to have these different perspectives on enforcement, PRC, non-PRC investors, and then what to do when there's aspects of fraud. I think the point that you mentioned, Jason, is really important, that when award creditors have joined several debtors, some of whom are the decision makers, it opens this whole host of options that we've seen. In that matter, as you say, we based on, sometimes when there's family involvement, it can help because it really allows you to convert the liability of one against a corporate entity, perhaps to against family members based on conspiracy, torts like tortious interference with monetization, with enforcement and things like that. I think the theme, if we could develop it, is that these situations are highly dynamic. And it's very difficult at the outset to look at a scenario and say, these are the problems that are going to arise, and these are how I'm going to surmount those problems, and then the risk adjustment for the likelihood of success or challenges. But it really is taking a few steps and identifying quickly and embracing opportunities along the way. We always say that the sweet spot for the arbitration practitioners to begin thinking about these things is about 6 months before they think an award is going to be handed down. And it's like buying insurance. Even if you don't have the problem, it's still good to have plan B. In the commercial context for clients, these are really a series of decisions with different risk profiles. And you want to look at the best case and you want to look at the worst case. I think we've had a really large range of perspectives here today, which is really nice. Hopefully it's provided some insight from different parts of the world to the audience. With that, I just want to open it up to questions for the panelists. Hi.
I have a question for
I think if you speak into the microphone, because she's remote, so she'll need to hear for that.
Hello. For I wanted to ask whether the minutes and the opinions address the scenario where an administrator is appointed by a Hong Kong court, and another insolvency proceeding is commenced in the mainland by another, let's say, another set of creditors, and a mainland court appoints another administrator. So in that case, who between these administrators take precedence with respect to the management of the assets of the insolvent company? Thank you.
Right. Regarding that question, I think that's addressed to me, right? So the Chinese court will not have a bankruptcy proceeding for a Hong Kong company. And the minutes and the opinion I just mentioned is you have a reciprocal arrangement where a Hong Kong company is bankrupt under the Hong Kong company audience, and then it get recognized in the mainland court. The mainland court, according to the Chinese law, that is the Chinese enterprises bankruptcy law, will not accept a initiation of a bankruptcy proceeding of a foreign country. So you can only have one proceedings in either jurisdiction, then you apply for recognition and assistance in another jurisdiction. Right, so there are not going to be a parallel proceedings. You initiate at Hong Kong, then you get recognized in China. I hope that answers your questions.
Yep. I think that raises a great point too, which Heidi answered quite well, which is sometimes a defensive maneuver can be to file a tactical winding up proceeding in an enforcement jurisdiction in parallel, or maybe even after the original one, to defend against recognition. So I'm being told the panelists can't hear the question. So if anyone has a question, I'll just try to repeat it into the microphone and then we can go from there. Okay. We'll see if this works. Otherwise, I'll try to repeat it.
It's a question for Ms. Lee. She's talking about intellectual property arbitrations and enforcement in China, and then the difficulties of getting all the time, not difficult, the time to get to the Supreme Court. I mentioned there could be a value in an award anyhow because of being able to prove the share price. I just want to understand that process, what she's talking about a little bit better. Is it that because you say have a dispute with someone who's a licensee or says they're a licensee in China, once you get the award that confirms they're no longer a licensee, you then have that more freedom to take infringement actions against them in China or other things? That's what increases value. So I just want to understand what the issue was.
Yep. Seung-min, were you able to hear that question? No. Okay, let me try to summarize. Actually,
Sorry,
forgive me if I slander this. So I think the question was, we're very interested in the experience with IP disputes in China and the leverage and opportunities that are presented, even if the arbitration award that is ultimately handed down is not directly enforceable. And so we wanted to just explore and get your views of what type of leverage that would be, whether the fact there's a declaration that there has been an infringement of the license allows additional steps to be taken both inside China and outside China, outside of the execution of the award. Is that fair? Okay.
And I guess infringement litigation in China may be opened up because the award is outside the license is terminated.
Right, and infringement litigation can be commenced in China because the award has now said that that the license is terminated.
Yes. So interestingly, I think you got the question is very, very smart in the sense that it understands how it operates, because when there's an arbitral award and when you take the arbitral award and when you're trying to commence a copyright infringement case before the Chinese court, you can go to the authority, you can go to the Chinese court to crack down these platforms. And even the authority, when they're trying to just crack down these things, they would accept these arbitral awards as something with authority, although it didn't go through the official route. So they would recognize that, oh, no, the license has been terminated and therefore there is no license ongoing. So ultimately there could, and even, well, for example, if you go to the Apple application shops, you can submit these together as a supporting document. Then they would accept this, although it's not a proper legal proceeding, but also they would accept it as a proof, and then they would shut down these games or like platforms. So that's how it actually operates. So it's actually powerful in the sense when you're actually implementing this this IP rights against these copyright infringers. And interestingly, these people, they're very well aware of the fact that who actually won in the although it's confidential, but because most of these companies are listed companies, so the end result is going to be listed and it's going to be announced to the world. So these people are very well aware and very versed of all the updates on these IP issues and how it's involved before the arbitral courts. Hope that's helpful.
I think that's very interesting. Dealing with government regulators as an alternative to enforcement, and I think opens up this area that I know you work in, Seung-min, which is really trying to borrow regulatory and criminal remedies to achieve a civil end for your particular client, whereas the civil remedies may not they themselves be that straightforward. And these regulatory bodies are extremely complicated, and it's much beyond just submitting a complaint and putting it in the complaint box, which may actually create a competing creditor against your client. And so it's very difficult to navigate, but it's quite fascinating. We do have a little bit more time. Thank you. So I'm going to take notes and repeat your question. I'm understanding the microphone. Yeah.
So, hi, thanks again for organizing this. I wanted to just follow up on Byron's question about insolvency in China. So, if we have a scenario where we have a Hong Kong company that we're trying to enforce against that has got the main assets in China, and so we appoint liquidators in Hong Kong in that case, but if the liquidators, Hong Kong appointed liquidators are not recognized in China, then what can we do?
Okay. Heidi, were you able to hear that? I know you heard the last question.
Yes, I think I hear quite clearly. If, unfortunately, the administrator will not be recognized by the Chinese court, what we usually do is, you have a bankruptcy administrator. Usually the contract provides you with the right to flush the board. So let's say we have a WOFI in China, then the Hong Kong company as the shareholder went bankrupt. So what we will do is have an administrator or provisional liquidator. Sometimes we have a receiver. It's different, quite different. The Chinese court usually is more, it's more easy to recognize the legal position of liquidator. A receiver is difficult for them to recognize because in China, we do not have the concept of receiver. Anyways, then we can actually have the liquidator be appointed as the board of director in this Hong Kong shareholder. And after the shareholder actually appoint the directors, then we will have a shareholder resolution. And also we will appoint someone as the new legal representative of the Chinese WOFI. That is to say, usually someone from an accounting firm, someone appointed by the Hong Kong court as an administrator, then it become the legal representative of the WOFI. Note that now we do not have company chart, we do not have business certificate, but we have a legal rep. So we have this legal representative. What we usually do is we go to the local AIC, that's the company registry in China. We try to file a report saying that we were not able to regain the company chart. So it might be missing or, we were not able to get that company chart. Sometimes we can actually have the chart remade. So if you have a legal rep, you have a chart, then you can reapply the business certificate. If not, what we usually do is we have the legal representative go to the Chinese court to file a case against the formal management or the legal representative that have been removed from the company, saying we need to this person to actually provide or hand over the company chart, company assets, or the financial charts, or the contracts, etc. of the company. And we apply with the Chinese court what we called evidence preservation. Then the Chinese court will go to that company, try to seize the company chop and other assets, for example, business license, copy of the business license. And if we have a winning judgment, what we usually do is we can enforce that. So the formal legal representative either hand over the chops, business license, or we actually tell the AIC that that person is refused to enforce, to honor the judgment, then we can have that remade. After we have everything remade, then legally, we are actually in control of the WOFE. Then we start to take over step by step. For example, if there's real property, we can actually have the certificate of real property, a title certificate to remade. Then we try to dispose of the same. But note that sometimes the liquidators, they do not want to become the legal representative because that means they might face a lot of litigation proceedings in China, sometimes even be listed as a dishonest person. Then they are refrained from taking the train or taking the airplane. So that could be a problem. That's what we usually do. I hope that answers your questions.
It's really quite interesting in these situations where someone clothed in liquidator powers has a certain set of remedies they can access. And if they can't tap into that, then they can clothe themselves in directors' powers, as you point out. And the company chop is a real challenge. You know, you hear these stories of people breaking into buildings to steal the company chop or getting into physical, fights and wrestling over the company chop and things like that. One of the benefits of being recognized, I think, is not to have to deal with that. Okay, I think we are at the end of time. If anybody has the last question, we can pose it. Otherwise, I think we can conclude. Okay, I didn't have any. Okay, I think there may be the Zoom chat, maybe questions or messages from the participants. I have the Q&A here that I don't see any on there. Is that right? Okay. Okay. Oh, one more. Thank you.
I'd like to address my question to any panelists. In the business world, the business of factoring is well understood, right? Creditors want money quickly and certainly can factor their accounts receivable either with or without recourse, offset a different price, get their money fast, okay, with certainty. Then in recent years, there is this practice of third-party funding litigation, right? So investors started the business of assisting litigation or arbitration to help the people to press their claims. My question is, do you see any room for a new business to be started? Or indeed, has somebody already started in terms of factory
would anyone on the panel like to take a stab at this? Otherwise, I can tag on at the back end.
I'm sorry, I didn't hear very clearly.
Oh, sure.
John, do you mind?
Please forgive me if, yeah, I do understand. Please forgive me. So I think the question was that there's an entire industry of factoring on accounts receivable, sometimes recourse, sometimes non. There's third-party funding that's increasing. And the question is whether the panelists think that there's room for a new market or a new business to factor arbitration awards, basically. I think to lend and then take a share of the return on the arbitration, secured by the arbitration award, essentially. Is that fair? Okay. I'm happy to take a quick stab at that. I actually think this is quite a deep market, although it's primarily in the West. So there's a lot of special situations desks at hedge funds and that are actually actively trading in arbitration awards. And it's a process for the holder to de-risk, and it's a question of how much investment people want to make and how much control they want for the case. But there are, it's completely legitimate. It's, places like the United States and in parts of Europe, there are cases that are actively being litigated that you have a traditional litigation funding model where there's a non-recourse loan And then you have situations where the claim can actually be assigned to a special purpose vehicle, and then people take membership interests, and there'll be a limited partner and a general partner. And so oftentimes with awards of a certain magnitude, the first question we get is, how do we package this to attract investor value so that that the award creditor, which is not in the business of collecting awards, can diversify their risk a little bit. And that risk in the hands of, say, a Centerbridge or other investment funds is more valuable because it's diverse. They may have 50 awards they're enforcing at the same time. So I do think it exists. I think it will, my personal view is that it will increase in prevalence. It makes a lot of sense for efficient markets to have people join, capital to these in order to share risk. So it's a great question. Thank you very much for everyone for attending. Thank you very much to the panelists. I think that concludes for today, but we will remain open for a little while so that people can meet one another. Have a great day. Great to see everyone in person.
Thank you so much. Enjoying the
Thank you very
reception.
much.
Thank you.
Thank you. Bye-bye.
It's a shame we cannot be there in person. Okay.
Yes.
Thank you.
Next time.
Thank you,
Next time.
John. Thank you,
Yeah,
everyone.
thank you.
Thank you.
you.
care.
Bye.
Eddie. Thank you, Jason.
Bye.